Good morning, folks. Jason Bowman here from taxresolutionacademy.com, and welcome to today's presentation of 7 steps to resolving every IRS collections case. During the course of the next hour, we are going to walk through exactly that, a 7-step process that you can use as a structure for working every collections case that you will ever see. The 7 steps that we're going to talk about are processes that you have to do every single time on every single case, regardless of the tax type or the type of debtor. Okay, so the purpose of today's class is to give you a big picture overview of the structure of a resolution case to enable you to work those cases more efficiently, which means that you can do them more profitably. For those of you that don't know me, my name is Jason Bowman. I'm an enrolled agent, certified taxpayer representative, and NTPI fellow. I specialize in collections representation. I've written about a dozen books on the subject, have presented over 500 seminars and webinars such as this one on the topic. I've built 2 tax resolution firms and have also started several other businesses. Our objectives for today's class: 1, list the general actions required to work an IRS collections case. 2, describe the conditions that must exist in order for the IRS to grant a case resolution. 3, understand the role that the taxpayer's financial condition plays in case resolution. And 4, define the most common IRS case closure programs. So we will begin at the beginning. And again, I want to triple, quadruple, quintuple emphasize this. Every case, every time, 0 exceptions. Please do not do this because I no longer respond to them. But in the olden days, I would have practitioners that would send me these emails that were really, really long. They took a lot of time to write these emails describing a client's situation. And then they would ask, what do I do next? Where do I start? And inevitably, I would tick these practitioners off because I would respond with a 1-sentence reply after they took all this time to write out this long explanation. And my response would be, have you done the account research and have you done a financial analysis? Because it doesn't matter what the circumstances are in a case. They literally do not matter. You start every collections case the same. You have to do this account research and you have to do a financial analysis, okay? Without fail. There is literally no exception, ever. It does not exist, okay? Always do the account research, always do the financial analysis. I cannot emphasize this enough. So with that stated, I will step down from my high horse and delve into exactly what I mean by these. So step 1 is the account research. The account research step answers the critical question of where is the client in the IRS collections cycle? The diagram that you see up here on the screen, this is the IRS Notice Cycle. Get a couple of bills, potentially an NFTL, first notice of intent to levy, second notice of intent to levy. Each of these has time gaps in between them. These time gaps give you time to do things to resolve the tax debtor's situation. Each of these notices has different responsibilities and rights. So you have different types of appeals rights that come with each of these later in the cycle. This is approximately a 4.5-month cycle. So for your typical 1040 debtor that actually files their tax return on time, this cycle will start roughly around June and in roughly October-ish. For a 941 debtor, however, this cycle never ends because a quarter for 941s is 3 months. This cycle is 4 months. And so this collection cycle is from the previous quarter overlaps the filing of the next quarter's 941. And so it is a never ending cycle for a business. And here's something you may not know. 59% of all IRS tax debtors are businesses that owe payroll tax. That is the majority of the casework that is available to you, not 1040. Okay, so I hope that helps make you think about some things in your business. The initial assessment notice that the IRS sends is a notice in demand for payment. And then that starts the cycle. Now, you probably already know that a lot of tax debtors have unfiled returns. There are some other business opportunity there for you in preparing those. The typical 1040 debtor owes for approximately 3 to 5 years worth of returns. The typical 941 debtor owes for approximately 8 to 12 quarters. And like I said, each gap in the cycle presents an opportunity for you to break the cycle. So what do you do during this account research phase? What are you gathering? What are you looking for? Well, you can call the practitioner priority service and gather transcripts over the phone, or you can wait for your power of attorney to post to the CAF unit and pull transcripts via e-services. This is normally the fastest route, but right now there's a 6 to 8 week delay in the ability of the CAF unit to post your power of attorney. On individual cases, there is now the option, if your client has access to their online account, that the process can go way faster, but otherwise, you're looking at a long time delay in getting the CAF unit to post your power of attorney. And there isn't a single thing that we can do to accelerate the process. It's just the reality of the IRS backlogs right now. Okay. To delve further into third-party authorizations, including your power of attorney and these CAF issues, you're going to want to attend Dan Henn's class, CTR 105, where he talks 2 hours in nitty-gritty detail about that. Now, what you're doing when you call PPS or you're pulling transcripts from e-services is you are doing a transcript analysis. Okay, you're doing a transcript analysis. You are looking to see if returns were filed. If they weren't, then that tells you need to file them. You're looking to see if the the IRS prepared substitute for returns, 6020Bs, on behalf of the taxpayer. And then you're going to have to assess whether or not you're going to replace those with original returns. Do not always automatically assume that you're going to replace every SFR, because there are plenty of situations where you are going to, it's in the best interest of the client not to replace an SFR. You're going to look for 1058 dates, these final notices of intent to levy, also called an LT11 if it's coming from ACS, the campus collections. You're going to make sure that payments were properly posted, or if they're missing. You're going to, in my recommendation, you're going to break out tax, penalties, and interest, and put that in the cover letter of the report that you send to the client, in order to educate them on how much it's costing them in penalties and interest to not pay their taxes on time. Now, you're also going to need to identify the collection statute expiration date for every tax period that your client owes for. The CSEDs are super important, because once they expire, the tax debt dies and the taxpayer no longer owes it. And so there are things you can do to help your client there. And then, of course, if your client has any notices that they have saved, because sometimes they shred them or burn them, sadly, you're going to want to review those notices if they still have them. Doing all this research is going to tell you where the client is in the IRS collections process, whether they're at risk of levy action, what appeals rights may be available to them. And it's going to tell you what the IRS's expectations are at that given point in time for your client's behavior. Okay, so that all educates the process that you're going to employ in order to best represent your client. And so what this information tells you, how you use it, what you do with it, will be nuanced with every client. But the account research step itself is for every case, every time, zero exceptions. The next thing that you need to do for every client, every time, zero exceptions, is the financial analysis. Your client's eligibility for about 90% of available resolution options is based on their financial condition. If you've never looked at a Form 433A, you're about to. On this, the Section 5, called the Income and Expense Table, is often the single most important item in the financial package for an individual debtor. Surprisingly, a lot of businesses also don't have much in the way of assets, and so the income and expenses become very important for business clients as well. So this is Section 5 of the 433A or B. If you are looking at a 433F, it's Section H. This is where the collection financial standards are applied for your client in individual cases. There are no collection financial standards for business cases, but even then, the importance of the financial analysis still applies. So this is the Form 433A, Section 5, monthly income and expenses. On the left-hand side of the table is the income. On the right-hand side is the expenses. The single most important thing for me to tell you about the income side on the left is that the income tax treatment of an income item doesn't matter. This is not a tax return. This is a monthly cash budget, for lack of a better term. So the income tax treatment of an income source doesn't matter. So Social Security, disability income, VA benefits, child support, these things that are not taxable income still need to go on the form because they represent cash that is available to pay monthly living expenses. Okay, so you have to take your tax preparer hat off when you're doing a lot of resolution stuff, especially the financial analysis. On the right-hand side of the grid, you are going to see some expense items that may look familiar if you've ever looked at the allowable living expenses, the collection financial standards. So this is where those collection financial standards are applied. And within our certified taxpayer representative curriculum, we have 4 hours of coursework, CTR 111 and 112, that delve into these. The most important line item here is the net difference between income and allowable living expenses. This number right here on line 50 is called remaining income. That is what the IRS calls it. So I will colloquially refer to it as disposable income because that's the term that your clients probably recognize. But the technical term is remaining income. So that's the 433A. So here is what it looks like on a 433F. Okay, this is the form that ACS will ask you to send. Okay, you're usually going to use the 433A when you're dealing with a revenue officer or an appeals officer. But ACS is going to ask you to use the 433F. It is the form that they know. What you're going to notice here is that the expense categories are broken down into a further level of detail. However, don't let that confuse you or anything like that. The allowable living expenses for each major category are the same, and your client is allowed the same expenses on the A versus the F. It's just that this theoretically makes it easier to do the math by breaking it down into more narrow categories. Okay. But understand it's the exact same number, the total for each section. It should be the exact same total as you get using the A. This is the section 5 for the 433B for businesses. Obviously, there are not as many expense categories because there are not specifically defined expense categories for businesses. Expenses need to be, the classic phrase, ordinary and necessary for the business. So when you're representing business taxpayers, and Keisha, to answer your question, what was the percentage for payroll tax cases? It's 59% of tax debtors are businesses that owe payroll taxes. Okay. And so part of what you get paid for is going to bat for your client to say, yeah, these expenses are ordinary and necessary for this type of business. Okay. So we use that remaining income number for a lot of things. That whatever dollar amount that is, that's how much the IRS expects to receive from your client each month if you're doing an installment agreement. It is also the number that gets multiplied by either 12 or 24 to go into determining the minimum offer and compromise amount. The financial standards and remaining income are also used to determine eligibility for CNC, currently not collectible status. So in other words, again, 90% of your resolution options for 1040 cases depend upon that remaining income number. For businesses, it's more like about 75% of your resolutions are going to depend upon that income and expense table, but it's still super important. And again, within the CTR curriculum, I'm going to refer you to CTR 111 and 112 and 301 and 231 for advanced discussions about the collection financial standards and how we apply them. And then our CTR 201 class covers business financial analysis tips for you. So next in our 7-step process is step number 3. Determine resolution options. What pathway is available for your client to resolve their tax debt? So here's where I need to provide you some statistics from the IRS and perhaps quash any assumptions that you may have about what resolution work is like. So the offer and compromise statute was passed by Congress back in 1965. And it has always been the least common resolution option available for taxpayers due to the strict eligibility criteria. In fact, if you look at the data from fiscal year 2019, you will find that less than 0.18% of IRS collections cases qualified for an offer and compromise. Okay, that's not 18%. That's not 1.8%. No, it's less than 1%. 0.18% is all. Okay. The IRS resolves millions of collections cases every year. Each year, right now, only about 17 or 18,000 of them qualify for an offer and compromise. Now, you might think, oh, 2020 was different because of the pandemic and the recession and all that. Nope. Last year, most recent year data is available for 0.19% of all closed collections cases were done so via an offer and compromise. So if you have ever had the assumption in your brain as a tax pro that tax resolution was all about doing offers and compromise, that is absolutely incorrect. Okay. In my entire resolution career, representing almost 400 taxpayers, I did exactly 4 offers and compromise. And 3 of them were all related offers: an individual, a business, and then his fiance. So they were related offers. So really, it was only 2 separate cases out of 400 that were offers and compromise. okay? Because most people simply aren't eligible. Once you start doing a broad swath of collections work, you're going to start seeing these trends for yourself. So you'll do very, very few offers in compromise unless you are intentionally targeting your marketing to a low income audience. Okay. That might be the one exception. And there are practitioners that do that. There are obviously some pros and cons to that particular business model. What you're also going to find, however, though, if you do a much broader spectrum of work, is that roughly 15% of your clients will be placed in CNC. At any given time, there are roughly 2 to 3 million Americans that are in CNC. Even businesses can be placed in currently not collectible status. The single biggest benefit of putting a client into CNC is that the clock on the collection statute expiration date continues to roll, okay? And so the CSED may expire while the taxpayer is in CNC, meaning that they may actually end up paying $0 on their tax debt. Now think about that real hard. You do an offer in compromise math, and they're going to have to pay X dollars based on their income and assets. But if you can get them placed into CNC, they may not have to pay anything. In some situations, CNC can be a better deal than an OIC. Bet you never thought about that before, have you? Okay. Sometimes a CNC can be a better deal than an OIC. It's just something for you to keep in mind. Roughly 5 to 10% of the cases that you work on will be resolved through either full payment or something involving disposition or refinancing of assets. This is what I refer to as lien work, aka lien-related certificates, certificates of withdrawal, non-attachment, subordination, and discharge. This by itself can be an interesting niche to work in, with some interesting marketing angles as well. So there's a whole business model that is lien work only that you could pursue if you wanted to. And they're really nice cases, especially in relation to real estate transactions. So everybody else that you represent, roughly 3/4 of the cases that you work on will be resolved through a payment plan. Okay. The vast majority of the resolution work you're going to do, it's not going to be offers and compromise. It's going to be setting up payment plans. That's what you're going to get paid for. That's the bulk of the work you're going to do if you specialize in doing collections representation. So what are the resolution options? What is the flow chart? What does the path look like? Well, this is going to harken back to step number 2, the financial analysis. In order to use the handy dandy flow chart that's up here on your screen right now, which I consider one of the more important slides in this entire PowerPoint deck, this requires that you have done the financial analysis. Because if you haven't, you're not going to know what they're eligible for. So in order to resolve the tax debt, you need to know where you're going. And the financial analysis is what determines taxpayer eligibility for these various resolution options. So real quick, if the taxpayer has assets in equity and the taxpayer owes the IRS more than $100,000 in individual tax debt, and it's assigned to a revenue officer, you're going to have to do stuff with the assets. If it's assigned to ACS and the liability is greater than $250,000, you're going to have to do stuff with the assets. And what's really going to happen is the case will be assigned to an RO. If it is a business liability, you're more likely to need to look at the assets. The IRS wants the taxpayer, if possible, to tap into any equity in their assets and pay that money over to the IRS. This is where you're going to have to get loan applications in and get those denial letters to appease the IRS. You also may need to sell an asset, which will require a lien discharge, or you may need to do a cash out refi on an asset, which is going to require a lien subordination. Again, roughly 5 to 10% of the cases that you work on will involve those lien certificates. And I cover these lien certificate processes in CTR 121, 221, 223, and 224. Yes, lien work itself gets a solid 8 hours within our overall 120-hour CTR curriculum. So after looking at the assets, or if the assets are not an issue because the tax liability is small enough, then you're looking at that remaining income number. And then what you get paid for is to do everything that you legally and ethically can to maximize the taxpayer's allowable expenses and minimize their reported income. And again, we cover what you can do legally and ethically in CTR 112. And then individual installment agreements, the 5 different types of individual installment agreements that exist are covered in CTR 132. If your client has no significant assets, which are by law subject to levy, and they have no remaining income, so that line 50 on the 433A is 0 or negative, then you're going to place your client into CNC. This is the second most common resolution type that you'll work on. Across many years, it'll average out to about 15%. In fiscal year 2019, it was almost 20% of cases resulted in CNC. We cover that extensively in our CTR 131 class. And then I've also already mentioned that offers in compromise are actually the least common resolution option. But we do cover that in CTR 133, and intermediate offers in compromise is in CTR 261, covering future income collateral agreements, doubt as to liability offers, and ETA offers, and dissipated assets. I just taught that class last weekend, so that was top of mind. So these are the resolution pathways that you'll be looking at. Step 4 out of our 7-step process is the actual phase where you enter into discussions with the IRS. So when you bring on a client, one of the things that you want to do pretty early is to request a temporary collection hold. My normal standard was always to request a 120-day hold. Very rarely did I get 120 days. More commonly, you're going to get 30 or 60. Okay, if you can get 60, great. If you can get 90, great. If you can get 120, great. If all you can get is 30, that's actually plenty of time in the majority of cases, okay, especially for individuals. Then, based on the account research that you did in step 1, you are going to look for any appeals rights, and you are going to exercise them. The exercise of CDP appeals rights in particular will buy you even more time, usually an additional 4 to 6 months, where your client isn't under threat of levy action, and it gives you time to work on step number 5, which we'll talk about here in a few minutes. During step 4, you're going to address any active or pending levies. This is where you might need to do cap appeals or other actions in order to get wage garnishments released, things of that nature. It is also where you are going to formally propose the resolution option that you identified in step 3 based on the financial analysis that you did in step 2. So this may require additional appeals. You may end up having to do lien work depending on the resolution pathway, and it may require that you prepare a full financial package, okay? Even if your client owes less than $250,000 and they're assigned to ACS, even if they owe less than $100,000 and they're assigned to an RO, you may still need to assemble a full financial package, a full 433A or B, if you go to appeals, because appeals, what am I trying to say here? The getting away with not doing the full financial package that you can do in lower dollar situations, that goes out the window when you enter the appeals world. Okay. They're going to want to see a full financial package with full financial documentation. which if you did step number 2 properly, you're not going to be fumbling and scrambling to assemble that package for appeals because you already did it in step 2. That brings us to step number 5, which is fixing the client. Now, by fixing, I mean a couple of different things. There's both an IRS side to the fixage, and there is a personal side to the fixing that needs to be done. So let's first talk about the IRS side. In order to enter a resolution with the IRS and ensure the client's long-term success with that resolution, you have to fix the underlying problems that led to the tax debt in the first place. This is part of the reason why the IRS has a requirement that your client be current and compliant in order for them to enter a resolution. Okay? The IRS will not grant a resolution if your client is still accumulating new tax debt, or if they are not compliant with filing requirements. I used to have a little dance, current and compliant, current and compliant, current and compliant. This is the mantra of resolution. Very early on, when you take on a case, you need to be thinking, what do I need to do to get this person current and compliant? What are the transcripts? Remember from the account research in step 1, you did that step. And so you know what they're missing. You know what payments are missing. You know what returns are missing. Okay. And you have to know that information. That's part of why you do step 1. So how do we get somebody current and compliant? Well, let's talk about current first. You get them current by picking a date. It almost doesn't matter. I mean, it needs to be relatively soon, but it doesn't need to be tomorrow. It could be next month or the month after. But within the next few months, we have to pick a date in the future where the taxpayer will start making their federal tax deposits for payroll. They're going to make them in full and on time and never miss another one. Or they need to make their estimated tax payment. And remember, estimated tax payments don't have to be made on the 4-payment schedule that we're all used to. You can make an estimated tax payment anytime that you want to. Okay. You can make estimated tax payments every month if you want. All right. But you have to pick a time period where you start making those estimated tax payments. Or if the taxpayer is a wage earner, then you need to get a new W-4 into their HR or payroll department in order to adjust their withholding so that the problem doesn't continue. And you need to document that. Like you want a little thing from their payroll department or HR department saying, yeah, thank you for submitting your new W-4. We'll get right on that. Okay. The whole point here is that we stop accumulating new tax debt. The IRS calls this pyramiding liabilities. Okay, so that's current. Let's talk about compliance. Compliant means compliant with filing requirements. Now, an interesting thing about this is that if you have a client that hasn't filed a tax return in 10 or 20 or 30 years, which those people exist, okay, you don't have to file 30 years worth of tax returns. Under policy statement P-5-133, the IRS states that under normal circumstances, they will only go after 6 years of returns at a maximum. Okay, at a maximum. Where does that 6 years come from? There is a 6-year criminal statute of limitation for prosecution for willful failure to file a tax return. That's where it comes from. So what's interesting though about it is that it's negotiable. I worked plenty of cases with clients that hadn't filed returns in decades, and we didn't even have the information to file accurate returns. And so what we worked out with the IRS was a deal where we would file one return. We would file the most recent year. And I attached a preparer statement saying this return is bogus. all the numbers are completely fabricated and made up. Okay, no, that's not what the preparer statement actually said. But it's based on the best available information with the taxpayer's recollection of their cash transactions for payments from their customers, as well as the application of the Cohen rule to estimate reasonable self-employment expenses. Here's the tax return. Okay. The reason that the IRS will do that is for two reasons. One, you get one tax return with an assessment that allows them, it gives the IRS something to bounce an installment agreement off of. Okay. There has to be an assessment in order to close out, in order to resolve the situation. Okay. So they want one assessment for one period so they can have something to place into CNC or into a payment plan or an OIC. Okay. So you do at least one, and then you enter the resolution. And then what happens is the government now has their teeth sunk into the taxpayer for future ongoing compliance. We've taken somebody that has been a tax deadbeat and we've converted them now into a revenue source for the government. Okay. That makes the feds a little happier. Okay. And they will hopefully collect tax revenue from this person going forward. Okay. So it gets the person back into the system. That's why they're willing to do that. So a lot of times, 1 year, 2 years, 3 years, 4 years. Okay. It's negotiable how many years back you're going to go, but understand it'll be up to a maximum of 6. I need to rewind a second. I realize I mentioned that I included offer and compromise into the 1 year situation. My apologies. That's an error on my part. If you do an offer and compromise, they're going for the full 6 years. Okay. There was a separate policy statement that was issued. You don't quote me on this. I think it was 2012 or 2013, where they added that requirement for the full 6 year compliance check. Okay. For an offer and compromise. But for CNC or OIC resolution, 1 year could be fine. It's negotiable. The point is to identify what needs to be done and negotiate the least amount of compliance that you can get away with on behalf of your client. Okay. Now that's the IRS side of things. Now we need to talk about like the client themselves. So for individuals, you will often have to address household expense issues, especially because they often exceed the collection financial standards. If you offer financial coaching services in your practice, there is an opportunity here for you to do a full-blown upsell of that service. You may also need to connect the taxpayer with other resources to address certain behavioral issues. Okay. This is when it's going to feel a little bit like you're a therapist or a counselor when you're working with these kind of clients. You may need to connect them with alcohol abuse treatment or drug addiction treatment or gambling addiction issues. You may need to refer them to psychologists, marriage therapists. There are other resources in your community that you're going to need to connect some people with. Okay. You need to have referral sources in your Rolodex in order to send those folks to them. On the business side, as part of your fixing of the client here in step 5, you're inevitably going to do some, I'm using air quotes here, light version of expense reduction consulting and management advisory services on business cases. I mean, think about it, especially with payroll tax cases. Pretty much the majority of payroll taxes that I ever worked on, part of that was telling the business owner, look, you have this much revenue coming in. You can only support a total, monthly payroll of this amount. You're going to have to let somebody go. So you become that, that management consultant that tells the business owner, yeah, you need to lay off 3 people. Okay. It sucks, but it's part of the gig. All right. So the level of that service that you need to provide is going to be nuanced, specifically to each case, but do know that it's likely part of the conversation you're going to have. So I use the word light here in a pretty limited way for collection cases. But some of your clients, if you choose to offer other types of cash flow management type services or advisory services, there's an upsell opportunity there for you as well, with a separate engagement and a separate fee, which is, if you've ever wondered, how do you turn a one-time resolution client into a client for ongoing services? This is how. Okay. You upsell them financial coaching, ongoing tax prep, expense reduction consulting, advisory work, and then the thing that I'm going to talk about in step 7. Okay. So keep that thought in your mind. So that is step 5. Now on to step number 6, which is the cleanup phase. So here, what you're going to do is you're going to have an end of case review to make sure that all your T's are dotted and your I's are crossed. Wait. Something seems wrong there. So you have to diligently check everything to make sure that everything's done properly. You're going to close out the taxpayer's file and all of your technology systems, your CRM and all that. And you're going to withdraw your power of attorney. Never, ever, ever, never keep your power of attorney, your 2848, active after you're done with a case, unless the client is explicitly paying you to do so. Okay. You could run into a situation where you keep your POA on file with the IRS. And so the IRS and the taxpayer both think that you're still their representative, but you think you're done with the engagement. And so you don't pay any attention to notices that come in on their behalf. You don't advise them of anything that the IRS is going to do. And then something happens. They stop paying on their monthly installment agreement. IRS levies them. Well, taxpayer thought you were still working for them. What are they going to do? They could sue you for malpractice. And if you failed to withdraw your power of attorney, your E&O insurance company may throw you under the bus. It happens all the time. Okay. So withdraw your power of attorney if you're not going to be paying attention to the stuff coming in for the client. And if you're going to be paying attention to it, you need to get paid for it. In installment agreement situations, at the end of the case is also when you're going to do either a first time abate, an FTA, or request a reasonable cause penalty abatement. Reasonable cause is a massive topic unto itself. The reality is the majority of tax debtors simply are not eligible for a reasonable cause penalty abatement, but you run through the checklist anyway, which I talk about in CTR 251, and determine if they're eligible. And if they are, then maybe you can get some penalties whacked. Which, if you can, it's always a really nice thing to do for the client. And a lot of times, if they are eligible for RCPA, it's the one like direct dollar thing that you can show in terms of a savings to the client, which in their mind can help justify your fee, even though your fee shouldn't need justification. But clients like seeing it, and it's a nice thing to do if you can get them a few grand off on their penalties. Then the last thing you're going to do is ask a question. Is this a client that you want to retain for other services? Do you, if they're a total deadbeat and they were a pain in the neck to work with, maybe you don't want to keep them around. But if you do, then you need to determine other services, packages of services that you could offer them. And I'll talk more about that here in a second. So again, as I said, penalty abatements are done after installment agreements. A lot of your clients are only going to qualify for a first-time abate. Some won't even qualify for that. And there's a bunch of reasonable cause criteria. If their inability to file or pay was due to an addiction problem, destruction of records, a death or serious illness in the family, hint, hint, COVID. Okay, I think we're going to see more of these. People needing to tend to family members, and so they kind of let some financial stuff. They just kind of ignore it for a while, and then they get a tax debt and some, their credit cards don't make the payments, and they get into some financial trouble because they're taking care of family. Okay, I think we're going to see a wave of more of those because of COVID-19. If there was any embezzlement or anything like that that prevented them from paying, then that can be reasonable cause. And then there's this weird thing called undue economic hardship, which we'll also see more of, again, because of the pandemic. And I cover these all again in CTR 251. And that brings us to step number 7. Step number 7, which is account monitoring. So again, you have to determine whether or not this is a client that you want to continue working with. It is a choice. Just like doing tax prep is a choice. Doing bookkeeping is a choice. When I was running my practices, I chose not to do tax prep and bookkeeping. Okay. I did not do seasonal tax prep work. So if you're sick and tired of tax season, hey, welcome to resolution. Okay. You don't have to do tax returns anymore. And you'll probably make more money too. So you have to determine what you want to do for a client or not do. Okay. Again, always withdraw your power of attorney after the engagement is done if they are not going to pay you for ongoing services. With account monitoring, you can typically, nationwide, it's going to vary depending on where you are and the type of clients, individuals on the lower end, businesses on the higher end. But $500 to $2,000 a year for account monitoring is not out of line. And what you're going to do is on a periodic basis, monthly or quarterly, whichever is appropriate for the type of client, you are going to pull new transcripts. You're going to have your 2848 or 8821 on file with the CAF unit at this point. So you have, you'll be able to pull transcripts through the transcript delivery system within eServices. So you're going to check, are they making their installment agreement payments? Are they staying current and compliant? And are there notices coming in that you're getting copies of that you need to advise them on? And sometimes it's going to be really simple stuff. For example, the IRS is required by law to send your client an annual statement to remind them that they owe money to the IRS, as if they don't already know, right? Then you get a copy of that notice and you fire off an email to your client saying, hey, don't worry about it. No reason to panic. The IRS is required by law to send you this notice. You already know, just keep doing what you're doing. Okay, don't worry about it. Or if it is something more serious, then you address it and help them out with it. So I first came up with this back in 2011. And yes, other people have also come up with it. It's not like I was the first one, but I hadn't heard of it before. So I consider it one of only 3 original thoughts I've ever had in tax resolution, which should tell you that you really don't need to reinvent the wheel in order to be successful in this business. Now, depending on your goals and the overall type of firm that you want to run, you may or may not want to incorporate what I call account monitoring into a comprehensive package of other services that clients pay you for on a recurring subscription basis. Okay. You might include items such as return prep, tax planning, financial coaching, investment management, bookkeeping, payroll, advisory, etc. There are a bunch of other services that you can lump together into a service package, and you might have like a bronze, silver, and gold package that includes different things, different meeting frequencies, different levels of tax planning and financial planning, as well as the account monitoring. Okay, if you want to retain clients and you want to transition your practice away from pure compliance work This is one way to start doing that transition. Okay. It also smooths out the roller coaster of your annual revenue. And it makes cash flows much, much, much nicer throughout the year. So the 7 steps that we just went through are the big picture pattern that you can apply to every single case that you work on. Obviously, there is a ton of rabbit holes we could go down. We are literally at the tip of the proverbial iceberg. I've mentioned a bunch of other classes within the CTR program. In total, there are 120 hours of material that we have created within the CTR universe. It is the single most in-depth and detailed tax resolution education program that exists. There is literally nothing else out there that goes into the level of depth that we do. And I sincerely hope that over the past 54 minutes, you've seen kind of the philosophy that we have about how we present continuing education. A big, big thing for me is practical application. I mean, I can sit here and yak at you all day long about what the Internal Revenue Code says, but how do you actually use that? What is the practical takeaway? What is the step 1, step 2, step 3 for actually doing the thing? That is the perspective that we try to teach all of our classes from. So if you like that approach, if you like just the practical utility of that approach, I think that you'll like the other courses within the CTR program. So our membership is broken up into 3 levels: the Foundations, Champions, and Titans. Our most affordable membership is the Foundations tier at $100 a month, and it includes access to the first 50 hours of the CTR program, the 25 classes that you see up here on this slide. Within our intermediate series, which is available at the Champions membership tier and above, we delve into some of the advanced classes. We get into a lot of this lean work stuff. We get into the business side of collections and into advanced audit representation as taught by my colleague Dan Henn. And then also our advanced classes for the high-end stuff are available in the Champions membership. Now, I know that there's a lot of programs like this in not necessarily, there are some that are tax resolution, but there's some on other topics like tax planning and expense reduction and advisory, things like that. A lot of those programs are like $5 to $10 grand up front that they want you to pay to even get started. I have never been a fan of that model. I think it's a little ridiculous. And so we have structured this under a pay-as-you-go approach. You can start out with the Foundations membership. You get the first 50 hours of the curriculum at a reduced rate to determine for yourself whether it's something that you want to continue forward with for earning the entire CTR designation. But you can save some money and do it at the lower rate, and then bump up to the Champions membership when it is appropriate for you to do so. If you run a firm and you have staff and you want them to learn resolution processes, we highly recommend that you bring your staff members in at the Foundations level to train them. Within the Foundations membership, we also have a variety of practice management and marketing tools to help you at the basic level. We have weekly office hours every Friday. You can bring your case questions to Dan for assistance with those. We also have live training and CPE on an ongoing schedule. And we also have a very helpful and supportive community. We have what I believe is the largest community of resolution-only practitioners in the country that are, again, dedicated exclusively to resolution. We don't talk tax prep. We don't talk bookkeeping, unless it's kind of in relation to a resolution case. We're laser focused on resolution within the Academy. And as you can see here, we have a lot of participation and some very knowledgeable members that are that graciously share their experience and wisdom, obviously as well as myself and Dan pitching in. So we would invite you, if you're maybe on the fence about whether the Academy is a good fit for you or not, then we have a no obligation 14-day trial for you. If you would like to take us up on that, head on over to the website here, taxresolutionacademy.com/test drive, in order to take us up on that 14-day trial. And again, to take us up on the 14-day trial, head on over to taxresolutionacademy.com/test drive. So thank you all for being here for this hour. I hope that this was helpful for you. And I look forward to seeing some of you inside the Academy in the near future. Thank you so much and have a wonderful rest of your day. Bye-bye.